right, how are y'all doing? Welcome to Green Card Guys TV. I'm your host, John Ting, and today's topic is what should I do when I receive a notice of intent to deny? All right, so today is April 3rd, 2023. I believe actually March 23rd, just a couple weeks ago, 1 or 2 weeks ago, USCIS already made an announcement back in January that March 23rd, 2023, they are not going to allow any more COVID flexibility rule. So if you received a notice of intent to deny or RFE or anything similar to that, you probably have a good idea what I'm talking about. It's going to be based on the deadline in the notice. Okay. So no more 60 days extra. You got to get your shit together. Okay. Get it together. Don't wait around. Okay. USCIS has been very flexible in a sense. Maybe not for you. I'm sorry. But they've been very flexible because of the COVID pandemic and everyone's living life like there's no COVID anymore. So I agree with them that they don't need to have this extension deadline or extended 60 days. I think it was great, but I think what had happened to some people is because they depended on it so much, maybe even lawyers, I'm not sure, but they could have missed the deadline. They could have missed the response deadline. So what we do as a team, okay, is that we set the deadline in our calendar. Okay, we set it 1 week before, we set it 2 weeks before. All right, so and we have a client call, a client meeting. So for example, I just had one today. Fortunately, in this situation, the client was proactive. They got notification before we did, which typically is the case. So don't give your attorneys a hard time if you receive the notice of intent to deny or RFE maybe before your attorney, because that's typically the case. And especially if you have access to USCIS online account, then you would have access to that first. Okay, so because us attorneys don't have access to your account, you would have to share those credentials to us. All right, so let's see here. If you have no idea what I'm talking about, this is called notice of intent to deny. Now, you might be wondering, well, I don't understand why my other friends or people I know, they just went straight through. They even got interview waived. And you're like, you talk to them about like, hey, what evidence did you provide? And you try to compare. I don't think people really go into that detail. Maybe I'm wrong, but you try to compare with them and you come to find out you're like, well, it sounds like I gave more evidence than you did. And you got approved with or without interview, but they didn't get the NOID or they didn't get an RFE. So look at this. You got to think they're not, USCIS number one is not perfect. And I do believe that to some extent that USCIS does, I don't know if you want to call it play favorites with certain countries of nationality. That might be a better phrase than say like discriminatory, but let's just want to put it out there. I see a pattern with these situations because we have plenty of clients where, maybe they just got married and they just got married. So they just joined each other's bank account or one bank account. And that's all that matters. USCIS cares about financial documentation in terms of you have it joint together, but they're not going to ask for every single bank account to be joined together, which most of our clients are a little concerned about doing that anyway, but just human nature. I get it. So, so by the time you just got married, you just got an account shared together, you probably might not even have one statement together. I always recommend at least waiting until one statement comes through the cycle. But we have our max plan is file your case in 30 days. Of course, you have to be married in this situation. But if you don't have a statement cycle already came through, then the bank would usually give you some kind of one pager that would say, okay, so and so joined your account or vice versa, right? So I'm sharing this because you might be receiving this and confused, right? You're seeing the news. We just sent an email out to everyone saying we just had a success story. We have success stories all the time. Fortunately, knock on wood, with a wonderful team. But there are situations where USCIS won't do it, review your case or analyze your case apples to apples, okay? In the same way that they look at someone else's case. I don't know why, but it's unfortunately true. I've just seen the pattern, even though we provided everything that the other cases have been approved without a waiver. Okay, so try not to freak out because it does, when you receive this letter from USCIS, whether it's on your online USCIS account or in the mail, okay, then it does have that word deny in there, but before that word deny, it has notice of intent to deny. So the government's trying to say, look, based on the evidence you provided, it's not enough. So we're giving you this one last chance to provide us evidence to overcome our intent. And so it's actually nice in a way that they're giving us this chance, right? Giving you this chance. So it's very important that you understand this. Friends, I'll take a break there and I want to share with you, we do offer free 15-minute preliminary discussion, just point you in the right direction. And it's free to you, okay, for social media followers. But keep in mind, we can't guarantee free for you for every single person. I did that last year and it just got overwhelming, as you could imagine. And we definitely want to help, right? But realize even my team has told me that me personally, that I have to charge for my own time. Otherwise, I don't have time to train them, right? So it's this give and take. So please understand, if you do want to chat with me one-on-one, I appreciate it. It'll be my honor. But for me personally, I charge $199 for 30 minutes. Some attorneys charge more, so be it. But you can speak with one of our premier attorneys if our care support specialists get you scheduled, okay? And there are other situations where you might not need to talk to a lawyer, but because we do have a free guide for many scenarios, such as like failure to maintain status and you were outside America for a long time, more than 6 months, we have a free guide we can share with you on that, for example. So you can browse it, take a look. If you absolutely need an appointment, then we'll figure it out. Our care team specialists will help you out, okay? Get you scheduled. Our mission is to help people live and work in America legally. So it's very important in that sense to support that mission that we share information with you on these live shows. So I hope you appreciate it. And if you do, folks, please subscribe, hit the hearts, click the like button. I greatly appreciate it. It means a lot to us because something about this algorithm topic, especially with the TikTok lately, it helps push it to other people who could be thinking about, or not thinking. That would be crazy if these social media platforms know what we think. But when you're typing something, they can feed it to those folks. All right. Which, by the way, if you already know someone who has an immigration question or thinking about filing, or in this kind of situation, already filed their case and have a problem like this, that of course is resolvable. You're welcome to share information with them. All right. And of course, you're welcome to send in a question in the comment section, YouTube, Facebook, Instagram, and I'll try my best to answer your question. But back to notice of intent to deny. It's not the best subject to talk about. No one likes to receive something like this because people think, number one, they think they're denied already, despite it's the language in the notice is a little bit confusing. If you've never had to read one of these before, we have experience, so we understand what to expect. And so here's one of, hey, Charles, nice to see you, West Charles. One of the things you need to know about these kind of cases, first of all, is that I was trying to find on the USCIS website to show you. Let's see. It's the standard, okay? The standard of evidence. This is what we learn in law school. Like, what is a level? How convincing does the evidence need to be? Okay, in general, we call evidence bona fides. Okay, so if your own lawyer, you talk to someone and says they use the word bona fide, you could be like, what the heck is that? This basically means legit documents. Okay, legit evidence. Okay. Let's see if I can find this on the USCIS website so you can feel hopefully better about it. Okay. There we go. So I'm able to share my screen. Hi, Ola. Nice to see you. Nice to see you. Welcome to the show. Let me see if I can share my screen. Yep. Please bear with me one moment. Again, you're welcome to ask any questions here in the meantime. YouTube, Instagram. Okay, cool. That's interesting. Okay, so let's see here. Let me make the font a little bit larger on my screen here. So you can see I'm on the USCIS.gov website. I love using government websites, not even my own website, to be honest, even though we do try to update it as almost every day with information. But it's, and the reason I say that, you have to look at USCIS website, especially if you're filing on your own or you have your own case that you already filed. So here it is, burden of proof, okay? Burden of proof. So here it shows that the burden of proof, like who has the burden? That is to you as the applicant or to attorneys, right? I don't like to say attorneys because really we're asking you for the evidence anyway. But of course, it's our job to help you organize it, to make sure like this matters, this doesn't matter, that's not applicable, or this is very helpful. Or we'll tell you, look, everything you just gave us is not helpful. That happens from time to time. So that's one reason to hire a lawyer. Um, let's see here. So that's the first thing. The second thing, what is a standard of proof? All right. So I'm scrolling down here. If you're on Instagram and you're like, what the heck is John showing? You're welcome to join us on YouTube. You go to greencardguys.tv and it'll take you straight to the YouTube channel. So because I'm sharing my screen on there, I don't know how to do it on Instagram. I'm not that tech savvy as much as I think. Okay, so here it is. Let me highlight it right here. It says the standard of proof. I'm not going to read the whole thing, but the more specific thing you need to know, the standard of proof applied in most administrative immigration proceedings, meaning like USCIS, is the preponderance of evidence standard. Okay, so it says, therefore, even if there's some doubt, not doubt that it's a legitimate document. And of course, number one, it has to be legitimate. It cannot be fake, obviously. But even if there's a little bit doubt, some kind of doubt, doesn't say how much, doesn't say 50% or more. It says if the benefit requester, so it could be meaning an applicant, foreign national, or sponsor, petitioner, if the benefit requester submits relevant, probative, and credible evidence, credible meaning the truth, okay, not a falsified document. So a credible evidence that leads an officer to believe that the claim is probably true. They use this in quotations, probably true, and more likely than not, then the benefit requester has satisfied the standard of proof. So what that means is, if you have all this evidence and it shows that you have a life together as a married couple, for example, and we argue, of course, every time to USCIS that this satisfies the preponderance of evidence standard. Okay, that's very important. So, if how it relates to other scenarios like a criminal law case, not immigration court, but criminal law case, that's what we call beyond a reasonable doubt. So you have to remove every single doubt that that person is, innocent. Because if there's any percentage of that person being possibly innocent, then that person's not guilty. So in this situation, it's different. This is a civil situation for immigration. This is a preponderance of the evidence standard. So if you receive one of these and you're like, man, I really did give everything to USCIS. Well, look, it's probably been several months now. You can provide updated evidence like the shared bank statement, bills, statements in general, credit card bills. I always think like checking or credit card bills are one of the best because if you use those accounts for it was a debit card or whatnot, or a credit card, then it could show all the activity right there. It's the best. So you don't necessarily have to give every single month of a utility bill. You could, but up to you if you want to print everything. But hey, if you receive a notice of intent to deny, it doesn't hurt to provide all this, right? But usually when we file a case at the beginning, we don't give every single month statement. in terms of like utility bills, because there's so many, right? You got the cable or potentially so many cable, cell phone. Shoot, there's like so many subscription things these days, like Netflix. So whatever, there's so many light bill, gas bill, maybe tuition. I'm not sure, but there's so many potential expenses there that it might be just better, put it on a credit card or your checking account to expense it. That'd be easier for the officer. So, and by the way, you, especially if you moved addresses and you want to get a new updated driver license, okay? And so typically by the time you receive this notice of intent to deny, let me take this off screen. You likely, not everyone's in a situation, you likely would, USCIS already approved your EAD, your work permit, and advanced parole. So you need your EAD, if you overstayed your visa, then you need your EAD to take it to your respective states, Department of Motor Vehicle or Department of Public Safety to get a driver license, right? So, so I always have to share a lot of caveats, a lot of disclaimers. Because some of y'all, if you don't have the work permit, you go to DMV, you're like, well, John told me to do this. Well, you have to have the EAD, the work permit. Every state could be slightly different. So keep that in mind. I do see some questions. I will definitely answer them soon. What other tip here? Well, yeah, so you need to get updated address, because I've heard of stories, fortunately not our clients, but heard stories where they go to if USCIS does require an interview and you go there and they're like, hey, well, show me your credit cards together, which really doesn't make sense because the credit card numbers are different. But at least a driver license, because that would need to show the updated address. Now, look, I get it if you don't have time, but if the old address is the same as both spouses, right, then I think that's understandable. But hey, on these, you can apply online, or you can at least start the process online, I believe, to renew or update your driver license. So why not try? Check it out. There's really no excuses to not get it done, okay? Unless you're like interviews tomorrow. So it's a different situation. There's so much to share. Let's see what else. Number one, if you don't have a lawyer, or let's say even if you do have a lawyer, because we kind of nudge you, okay? We're gonna say, hey, where's your evidence that we asked for? We'll send you an email. So put it on your calendar, okay? It's a favorite phrase, one of my lawyer friends, and he says, put it on your calendar so you can remember to get it done, especially when this is so important to your case. Because look, if you miss the deadline, all right, so let me just say, like, it's April 3rd now. Let's just say it's like April 28th is a deadline, and you mail it out April 27th. Even if it was April 26th, yes, you could probably do like FedEx overnight. But look, you don't want to create that stressful situation for yourself. So let's say you received the notice today, create a deadline for Friday for yourself. Create another deadline for the next Friday, okay? I call it internal deadline. That's part of our process with our team, or what we call a production team, the legal team, because we don't want to miss a deadline for a client. Okay, that's absolutely important that we do not miss a deadline. I don't want to disappoint any client in that sense. So if you're filing your own case, you're like, look, you're not that organized. You're not that, even though I'm giving you these tips, it'd be our pleasure to help you the rest of the way. Okay. But you at least need to give us a call. All right. Give us a call when you're off of work, or text us when you're at work. Let's see here. But yeah, so you can get it done, because you don't want to miss this. You don't want the government, USCIS, to think, especially if it's a marriage case, that you've entered into it fraudulently, which they shouldn't do if the documents are not fake, but USCIS does some crazy things. So don't let them assume that you're in a fake marriage just because you didn't respond to the RFE or didn't respond to the notice of intent to deny. Okay, so it is typically 30 days to respond. From the countdown starts from the date on the letter. Okay, so if it says April 1st, then 30 days from April 1st. It can be confusing with numbers. I know it's been a long time since I've taken a math class. It can be confusing. There's a website, I think, called Time and Date, or dateandtime.com. you want to calculate for yourself what the deadline would be and put it on your calendar. And so the other reason why we have multiple deadlines on our team internally is so that even if we can mail it again by next day or 2-day delivery, ever since the pandemic, maybe even before it, even though these courier delivery services say it's quote unquote guaranteed, what kind of repercussion can we put to them if they mail it late, right? So is it worth suing them for it? Probably not. So it's always in your best interest, in our client's best interest, to file it at least 1 week before. That's always our goal. I get it if it takes you a while because maybe your bank, you can't access online your bank, and you go in person and they're freaking slow for some reason, then that might be a good idea to switch banks. But things can be crazy. So it's always better to start early, like literally the same day that you get this notice. So for example, a client I just spoke with this morning, they already uploaded a whole new folder called new evidence, and it warms my heart. We love seeing that, because that allows us to go ahead and start working on their case, resume working on their case today. And then we can even file it maybe this week, okay, if we get everything we need. All right, so there's could be so many tips. Thanks for tuning in. Again, I'm going to answer a couple of these questions here. So if you're just joining, you're welcome to drop in a comment with the question, basically, or tell me how you're doing. Hopefully you're well. Today's Monday, April 3rd. But yeah, if you're just now joining, we do offer free 15-minute preliminary discussion. You could give us a call directly, on YouTube and Facebook. It's right up here. Or you can, go to our website, greencardguys.com, go to contact us page and answer a couple of questions, or go right here on YouTube and Facebook, freevisaquiz.com, and you can answer a couple of questions there. All right. Now on to West Charles. You say your son sponsored you. He's working, not making much money, but I'm working. Can I use my income? No, if you do not have an EAD, okay, if you do not have a work permit through USCIS, you cannot use your income, unfortunately, okay? Even though there's a form called household income, you could use as like a household member. That person has to have status. You have to be a resident or a U.S. citizen to use someone like a joint sponsor, for example. Or even if it's another household member, maybe you have another adult child, or basically an adult child. So hopefully it gives you an idea. Some things I've been asked of us lately by clients is, oh, you do have work permit. Okay, that's great. Wonderful. If you have work permit, you can use, you probably got the work permit through the temporary work permit. So you should be able to use it because you have that. All right. But, people have asked about the primary sponsor. Does the sponsor have to show income from last year? Generally, no, because, pandemic and everything. A lot of people switched jobs, did some side hustles, did their own thing, quit their job. I get it. So the income could have been zero. Let's just say that, zero. What USCIS cares about is current income. So, Wes, let me just safely assume there's a household size of 2 with your son being the sponsor. Then let's see if I can pull out this page. 864p. Share my screen. So this is the 864p chart. I'm just going to assume you're in one of the 48 contiguous states, and household size of 2 is 24,650. Okay, so you'll see that there. If it's a household size of 2, and you look at the pay stubs. All right, we always prefer to send USCIS the last 3 months of pay stubs, and we just do whatever the frequency is. The hours might not be the same. And if it's not always the same, by the way, then you want to get a letter from the employer. Okay, so at least they can put together like an estimate based on the average hours. All right, but if you file your own and you get an RFE for stuff like this later on, which is standard, it can happen, then you want to send in a form, okay, for your own income as well, if you have to. All right, so hopefully that helps. Let's see here. Christian Candia, another great question here about when is as soon as immigration applications fees will go up. I think it could have been as soon as now. Let me see if I can pull it up on the um, final rule fee increase. Let me see if I can find it real quick. Okay, the latest I see something. I'm trying to find it through the government website. All right. Okay, let me see if it'll take me here. You're welcome, Wes. Happy to help. All right, so this is from their announcement back in January. They extended their comment period through March 13th. So comment period is typically 30 days. Basically, anyone like us, you, me, can put a comment, basically a concern, or it could be for it or for against it. So let me see if I can open it up. Thank you so much for asking, Christian. So then, but I realize this is I'm sharing this on YouTube, and you're on Instagram asking this. So I'll walk you through this. Hey, what's going on, Chino? I am Chino. Nice to see you. Okay, so I'm trying to find the one about the fee increase. Huh. Interesting. I just typed it in. Okay, here we go. Because it might say when it's going to take effect, but they didn't. USCIS website has not announced it in terms of when it will take effect. So far, the action just says proposed rule. It says extension of comment period, which is over. It's now April 3rd. Yeah, and all comments have to be before March 13th. Let's see, more details. No, that's it. Okay. Yeah, so I suspect it could happen soon. All right. So if you have not filed your case, whether any kind of application type, and you're eligible right now, file it. Okay. Don't wait. Fees, whether it's a waiver or something else, these fees are getting more expensive, especially waivers. But they're breaking up the fees. If you're in the U.S. and you're eligible to apply for adjustment status, aka green card, they're breaking it up. So now you have to file or pay another fee for the work permit. Yes, this is live, Chino. Coming to you live, brother. So let's see here. But I'm jumping off soon. I need to get to a team meeting. So if you have any questions, you're welcome to comment down below. If I don't get to you in time, you're welcome to call in or send us a DM. One of my team members will reply to you and get to you soon. Yeah, I am Chino. You're welcome to ask a question. I hope to answer, but every time someone asks that, they have some kind of joke for some reason. Let's see. Yeah, I was trying to see if there's anything else on the USCIS website about this, but nothing yet. Okay, let me check the newsroom just in case. No, nothing yet on newsroom. There's just about like H-1B type stuff. Yeah, that's about it. There's a lot of new things going on with USCIS, so stay tuned for our email updates. If you don't have if you have not signed up for our emails, we send lately we've been sending like 2 or 3 per week. So I apologize if you get annoyed, then don't just sign up, but or sign up for now. And if you do get annoyed, then unsubscribe. But I hope we try to share things that are of value, not just like this is how you get a green card through marriage. Not like that. Just way a little bit more specific in terms of tips that actually of value that can help you, especially if you want to fire your own. Okay. I am Chino. Your case is filing for spouse since November 2022. 5 months left, or maybe 5 months ago. What can I go if they denied? I'm trying to follow your question here. Where I think you're trying to say what to do if they denied her visa for Brazil to USA. Okay, you mean like a visitor visa or a marriage visa? You're Cambodian, your wife is Brazilian, you're a citizen of USA. Okay. Okay, cool. Congratulations. You say your wife is pregnant. Okay, you filed a petition for her. You want her to come to USA and yeah, file tax together. You think 5 months left on USCIS app decision? Possible. I mean, again, the petition is only step number one. It's only the first step. Okay. So if you're she got denied. Okay, well that's different. Oh, okay. She got denied for B1, B2. Okay, yeah. I mean, by the way, folks, if you're just tuning in, we're just answering I am Chino's question about the I guess in general about marriage visa and timing. But he's just said that his wife was denied the visitor visa, and if you got married and then you filed for the DS-160 for visitor visa, yes, it will highly likely be denied, because then it will typically it won't be denied for everyone. Okay, it depends on your true story of why to come into the U.S. But they don't they it's a visitor visa is a non-immigrant visa, so of course you're supposed to legally come back to or just leave the United States before the authorized stay expires. So when they see that on the application, then they're going to assume that your spouse is going to stay in America, right? uh right. Well, the I-130 would definitely need to show that you're married to her. But I'm talking about the DS-130. DS-160. Sounds like I am Chino that you might need to give us a call. Okay, going to go into more detail about that. But yeah, don't. If you say 5 months left, that's just quotations, And even if USCIS or estimation, I mean, even if you go at USCIS website to check processing times and whatever it says on the processing time schedule block, whatever they want to call it, timetable, it's not a guarantee. Okay. If they say 10 months on there, yours could be 11 months, but USCIS doesn't care. What are you going to do? Sue them? Yeah, that's what we would do if it's under unreasonable time period. Like, look, if it says 10 months, but yours is 11 months, we're not going to sue. That's not unreasonable delay. So it has to be pretty significant. Like we've had clients where, let's say it's typically like 8-10 months to process a petition. Hey, some of our cases I just mentioned the other day, like we got approved in 3 months, right? But that's not typical, historically, right? So historically it's like 8-10 months, 8-12 months. So, but let's say it's like 16 months is still processing, then that's when we would sue, okay, for petition. So that's just one example. Everyone's got a different scenario. Yes, I am Chino. There is an expedite or a pathway for expedite request, but I have a video about that on YouTube. So find that. I think you just go to my channel, greencardguys.tv, and then you search how to expedite. It'll be there. Okay. I do believe we have a free guide about it to show, like, explain to you the steps or whatnot, what you need to prepare just in case. But yeah, for your wife being pregnant, you can try, because of course pregnancy is not easy. I have 2 little kids. So, I mean, of course, I don't know. I'm not in my wife's shoes, but it's always helpful when the other spouse can be there to help out, right? So, but again, that's not a guarantee. USCIS would approve your expedite request. Oh, nice. Okay, Chino, thanks for the follow. I appreciate it. Yeah, if you don't mind, hey, go to Ting Law. If anyone has received any value and you're just you're following, you're getting some value from these live shows or recorded shows, please go to reviewtinglaw.com. It would mean the world to our team, because they do their best to email you a free guide or anything else to point you in the right direction. Okay, even if you haven't talked to us one-on-one. But of course, we do offer free 15 minutes. So if there's any point that you believe that would be helpful and we could help you out, even if it take over the case the rest of the way, we're happy to do that. Thanks, Chino. Yeah, so yeah, some people get denied for pregnancy, but hey, it doesn't cost any extra money to ask when you ask for expedite requests. At least you can tell your wife that you tried, right? So that's the important part. You might want a screenshot so she knows you're telling the truth. So hopefully that helps. Directly, you can call us. I mentioned this earlier. You may have just joined later, but I'm not the primary person to give the consultations anymore because I train my team literally every day. My team is probably annoyed at me, but we want to make sure there's no gaps in communication with clients and things like that. So I have a team of premier attorneys to help you consultation. If you still want to speak with me directly, I'm happy to help. But my team told me I do have to charge for that now. So it's 30 minutes for $199. We can chit chat about life, but it's really to time block, to be honest. Okay, I have to reserve time for me to manage a team and train and do casework as well. So, and live shows. All right. So, but I appreciate the request. I am Chino. Appreciate it. All right, Ola. I was wondering when you're going to send in a comment or question. So this will be the last one I can answer. That I really got to go to team meeting. Let's see here. You received RFE for 864. The intended joint sponsor is currently a joint sponsor for someone else and wants to know if sponsoring me won't affect the other person's case. Okay, so let me see if I can find those instructions for you on the 864. Okay, so you have an idea. Let me see if I can find it. Let me see if I can go to the form itself. In general, it should not affect it, but well, it depends on the income that your joint sponsor has, right? So let me see. Let me see if I can scroll down. Okay, add to stream. So I'm showing now. Okay, right now I'm answering Ola's question. Sorry if I mispronounced your name. I'm trying to make this form a little larger. This is the 864 form that a joint sponsor would sign. We are on page number 3, and in the top left section, part 3, number 29, it says, enter the number of immigrants you're sponsoring on this affidavit. So this affidavit would mean this specific case, right? So it's not about other family members as part of this case. However, down here on page number 4, the next page, okay, person is this person you're sponsoring this affidavit. So typically 1, unless it's like a family preference case where someone's abroad. And then let's see here. Number 6, it says if you have sponsored any other persons on 864 who are now permanent residents, then you have to enter that number here. So I'm assuming your question, Ola, is based on that person is not a resident yet. So so actually, by what it appears here, you don't have to include that person. But yeah, generally this type of question comes about when that previous person sponsored is already a resident. So this is actually interesting. It doesn't mention for like a pending case. It's not final. It hasn't been decided on yet, right? So yeah, that's interesting. But yeah, give us a call if you have more questions about that. Hopefully that was helpful. Okay, Ola. So that's his question right there. He asked for RFE on that. All right. So typically, RFE for these affidavit sponsor about financial documents, it's not necessarily. I don't believe it's because they're saying, "Oh, I know about this other case that your joint sponsor, your friend or neighbor is helping you, sponsor." I would believe they're very specific. Typically, sometimes USCIS officers like blah blah blah, like they just copy and paste from someone else's case, and you're like, "What the heck? I provided all those documents. That's a little weird," or has someone else's name. But in this scenario, it is common for USCIS to send an RFE about 864. Now, look, if you receive a denial letter and it mentions like, oh, you didn't provide XYZ ABC document for the 864, then that's not common. Okay, typically I've seen that come to me where I was a second lawyer, where they got denied and the previous lawyer did not file 864. We always provide it if we know someone's eligible for AOS, adjustment of status. But typically 99.9% of the time, USCIS will send an RFE for A64 before they would deny it. Okay, so it's a good thing you got it. Hopefully it helps. Maybe after the recording is, or I mean, not recording, after the show's done, you can send this to that joint sponsor. You're welcome to do that. But of course, ultimately, I have to say this is not legal advice, but this is free information of value. So hopefully you would take opportunity to give us a call or answer a few questions on our website so we can chat with you. Okay. All right. Y'all have a wonderful day. Okay. Don't work too hard. Of course we do. I have to tell my team work hard. All right. Take